The Honorables, the presiding judge and judges of the Court of Appeals of the state of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Good afternoon.
Good afternoon, everyone. I am Lucy Inman, and I'll be presiding in this session of the North Carolina Court of Appeals. And joining me on the panel are Judge Valerie Zachary and Judge Darren Jackson. We are conducting today's oral arguments by WebEx by order of the court because we've had some exposure in our court family and are very glad to have this technology so that we can go forward. The first case we'll be hearing this afternoon is State of North Carolina versus George Michael Steen, Court of Appeals file number 21-725. This is from Lincoln County. And counsel, are you ready to proceed?
Yes, Your Honor.
Very well. We will hear from the appellant.
May it please the court, my name is Mary Elizabeth McNeil, and I represent the appellant in this case, George Steen. I would like to reserve 5 minutes of my time for rebuttal. In this case, counsel failed to do the investigation needed to prepare a meaningful defense of Mr. Steen. Trial counsel did not investigate MS's counselor's records or his sister's DSS records. So counsel had no idea that MS's sister sexually abused MS in his biological home prior to MS living with the Steens. Mr. Steen was MS's foster parent. MS alleged that Mr. Steen had engaged in oral and anal sex with MS when they took showers together. There was no physical evidence. The state's case relied on the credibility of MS. The state's theory of the case was that while MS did lie, these allegations were not something a child his age could make up. Therefore, MS must be telling the truth about what happened and who did it. The information in the DSS records would have given Mr. Steen a viable defense to the state's case because the information in the records provided an alternative explanation for MS's sexual knowledge and a reason for MS to lie. Without this information, trial counsel could not develop a viable defense. Under Strickland v. Washington, Mr. Steen has to show that trial counsel made an unreasonable mistake, and but for that mistake, there is a reasonable probability that the outcome of the trial would have been different. Mr. Steen can show this, and he is entitled to a new trial because he received ineffective assistance of counsel. The first prong of Strickland is, did the attorney make an unreasonable mistake? Given the IDS performance standards, the information in the state's discovery, and the state's theory of the case, it was unreasonable for trial counsel not to request an in-camera review of additional DSS records and Teresa Griggs' notes. It was critical for trial counsel to provide an alternative explanation for MS's sexual knowledge. The information the trial attorney had, Teresa Griggs was MS's counselor. She was willing to cooperate and had information that she believed would be important to Mr. Steen's defense. To share that information with trial counsel, she needed a court order. Trial counsel never sought a court order. The DSS records that trial counsel did have indicated that MS's sisters were engaging in inappropriate sexual behavior was MS. The sisters had never lived with the Steen, which indicates that MS might have suffered sexual abuse in a biological home. There was sexual abuse in MS's biological home. MS's sister was sexually abused by her stepfather, MS's biological father. The sexual abuse occurred before the 3 children entered foster care. The Supreme Court of the United States has made it clear doing some or even substantial preparation on a case is not sufficient if the circumstances call for more work and investigation. The circumstances of this case called for an in-camera review of DSS records and Ms. Griggs' notes. Trial counsel had more than enough information to make a plausible showing that the records would contain evidence material and to the defense.
Ms. McNeil?
Yes,
Sorry. You mentioned the IDS performance standard,
yes.
and counsel for the state has argued in briefing that those are guidelines, but that those are not standards. What's your response to that?
Well, they are guidelines, but they provide information on the things to consider as far as investigating a case and the options that you have and what a trial counsel should consider doing. They are not required, but it is guidelines for how IDS wants appointed counsel, how they should approach a case and things that they should consider doing in investigating a case.
Do you concede then that it's not the standard of practice? The IDS guidelines don't provide the standard of practice?
Well, they do provide a standard of practice. I guess what I'm not saying is there is not a requirement to do when it comes, there's no requirement that if you have a DSS case, a case involving sexual abuse, that you have to get an in-camera review of DSS documents. They are standards as far as these are the things you should consider doing and should do if it is appropriate in your case.
Okay, and just to be clear, has this court or the North Carolina Supreme Court held that the first prong of Strickland was met when counsel failed to follow these IDS guidelines?
Not that I am aware of, not explicitly, no. It's something they have considered. I mean, I certainly have argued it, but I don't know that there's been a specific ruling that says violating these guidelines is enough to meet the first prong.
But you're representing to the court, there's also not been a case in which the court has explicitly rejected that argument either?
Correct.
Okay, thank you.
Well, did the DSS records or therapy records reveal anything that defense counsel didn't already know?
Yes, they revealed that MS's oldest sister had been sexually abusing MS and his younger sister, and that the abuse included one incident of anal sex between the older sister and MS. They also revealed that there was pornography in the home, that the stepfather was sexually abusing MS's older sister, that abuse involved oral and anal sex, and that MS was in the home when it happened. And it also provided a reason for MS to lie about who did it. MS wanted to return to his birth family. His mother's rights were never terminated, and the mom, he was still having supervised visits with his mom and his sisters. And so it also would explain why MS would falsely accuse Mr. Steen of this behavior. So given all these circumstances, what he had before, the trial counsel had before, he had more than enough to make a plausible showing. And post-conviction counsel was able to get an in-camera review of these records. And as I just explained, they were very important. They contained some very critical, important information. The state's case rested on MS's credibility and specifically his knowledge, his atypical knowledge of sex. 2 experts testified that a child MS's age could not make up these allegations because they don't have the knowledge to do so. S testified on direct. It was, one of the first questions he was asked was, who did he learn this behavior from? And he responded, Mr. Steen. The jury saw the forensic video, and in that video, when asked, MS said that it was Mr. Steen who taught him about oral and anal sex. The trial court allowed in an incident after MS left the Steens, but before he made the allegations against Mr. Steen, there was an incident where MS had engaged in with anal sex with 2 older boys. The trial court allowed this evidence in because the state had made such an issue of MS's atypical knowledge of sex. So a big part of the state's case was arguing to the jury. Of course, the trial counsel did not have closing arguments reported, but you can tell from the questioning and the reaction of the trial court that a key piece of the state's case was this child may lie, but this child cannot lie about something like this. So that's what the jury heard. What the documents revealed and what the jury did not hear was that MS father sexually abused his oldest sister. The abuse included oral and anal sex and showing the sister pornography. MS was in the house when the abuse occurred. The older sister admitted to having sex with her siblings. The older sister reported that when MS was young, he was still in a toddler bed. She asked him to engage in anal sex, and he did. That MS and his oldest sister had vaginal sex in a closet, and that MS had a reason to lie about who did this and how he learned this behavior because he wanted to reunite with his family.
If you could just remind me, Ms. McNeil, how old was MS when you're pointing out that he was in the house when his father abused his older sister?
He would have been around 4. He was born in 2000. There was confusion about when his father committed suicide. Some reports said 2001. We checked his birth certificate. His death certificate. He died in 2004. So
okay, so that's a big difference in the life of a.
Yes, Your Honor.
Okay, and then the age of MS when you're pointing out that the jury didn't hear evidence that he engaged in anal and vaginal sex with his older sister.
Correct.
And what age? Same age?
It would have, I believe the incident of anal sex happened before they were put in foster care the first time, based on when the oldest sister reported it. And I believe she reported it after they had first been taken away, but before the 2-month reunification. Okay,
and so the anal sex before they were first put in foster care, MS was approximately how old?
He would have been I mean, I don't know exactly, but he would have been he would have had to have been 3.5 or 4.
Okay, great. Okay, thank
And
you.
of this abuse, the only time MS was living with his sister was prior to when all 3 children were removed from foster care or during the 2-month reunification.
Okay,
MS claimed that the sexual abuse with Mr. Steen started after the reunification. MS had been with the Steens. The children went back to live with the birth mother for 2 months.
right.
Then after a series of placements, MS went back to the Steens. And he alleges that it is during that second long stay is when the abuse occurred. But as far as the sexual activity with his sister, for that to happen, either time frame is before MS alleges the abuse by Mr. Steen started.
Is there any evidence before the court that he watched pornography in his, in the home of his biological mother? Either, before he was initially placed in foster care or, in the reunification?
There is not. That would be something, certainly that would be grounds for further investigation, as would what he may have witnessed in the home between his father and his oldest sister.
But, I mean, how do you respond to the state's argument that what he experienced with his sister was male-female anal sex and not male on male?
Well, I mean, I don't think it really,
I'm sorry?
I don't think it is, I don't think it really matters. I don't think it's important. I mean, the oldest sister, I believe her direct quote is, I asked him to stick his thingy in my butt, and he did. And the allegations against Mr. Steen, involved anal sex, and both, MS, performing, according to MS, performing anal sex on Mr. Steen, and Mr. Steen performing anal sex on him. So this provides one definite explanation or a different source, a definite different source for MS's knowledge, and 2 other possible sources that would need to be explored. In talking about the prejudice prong of Strickland, but for this mistake, is there a reasonable probability the outcome of the trial would have been different? I'd like to point the court to State versus Johnson. In that case, the defendant asked for an in-camera review of DSS records. The trial court turned over some of the records, but not all of them. On appeal, this court granted the defendant a new trial because portions of the records that were not turned over to the defendant, information favorable to the defendant and material to the defense. Johnson was a Brady case, but the standard in determining if evidence is material under Brady is the same standard that is used to determine prejudice under Strickland. Is there a reasonable probability that the outcome of the trial would have been different? In Johnson, the information the court found material was an indication that the child in the case may have been abused by an older brother. The mother of the children had commented that it was a possibility to a social worker. The Johnson records also contained information tending to show that the child had lied to the social worker about the cause of her injuries. The state argued this was cumulative because the child's credibility had been challenged at trial. The court found the information in the file found that the information in the file was different because it showed that the child lied to a social worker about alleged abuse. The jury had heard information about whether the child had a reputation for lying to her family. Mr. Steen's case is similar. SS records show that MS was sexually abused by his sister. She forced him to participate in the same sexual act, anal sex, that MS later accused Mr. Steen of. Moreover, the records show that there was pornography in the home, and MS was in the home when his stepfather forced MS's older sister to engage in oral and anal sex. These records provide one definite and two possible alternative sources for MS's sexual knowledge. The records also provide a reason for MS to lie.
Mr. Neal, I'd like to ask a question. A couple of times you have referred to MS being in the home, and I believe one other judge asked you about when the suicide was committed. And you gave a date. In the record, isn't it true that all the records refer to the suicide as being in 2001 when MS would have been an infant?
I think the records, my understanding is that the records had both dates in them. And therefore we looked up checked the death certificate, and we, I can't remember if we put it in our motion for appropriate relief or,
From my recollection, read the motion for appropriate relief, you actually alleged that it happened in 2001. The exhibits that were attached to it, like Exhibit 1, the notes say it was in 2001. And to me, that's a big difference, because someone reviewing those records would have assumed that the MS was only an infant at that time. And it seems like your argument is kind of based upon MS being in the home when all this was happening. I assume that also means and not being an infant at the time, not being in a crib.
correct. And we noticed that there was some confusion. We checked the death certificate. We informed the assistant district attorney, and I believe we put it on the record at the evidentiary hearing that the death was actually in 2004. And 2004 was when they were removed from the home. So
should we be able to find the answer to Judge Jackson's, when you say that we put it in the record at the evidentiary hearing, that would mean that Judge Bridges would have heard that? Is that correct?
that is my, yes. I would also say that there's no dispute that MS was taken out of the home in 2004, and that he was in the home with the oldest sister until he was 3.5, 4 years old. So even if he was not old enough to have been aware of what was going on in the home as far as his biological father sexually abusing his stepsister, he certainly would have been old enough, he still would have been with the sister, and the incident involving anal sex in the toddler bed still, would have happened before he was removed into foster care.
But Judge Jackson's question about how old he was when his father died certainly would go to the importance or irrelevance at the other extreme of the fact that his biological father showed pornography to his sister.
Yes, it would. It would go to that and whether Michael was aware of what the biological father was doing.
But if we look in the transcript from the evidentiary hearing, we should be able to find out what Judge Bridges was told.
We either corrected it on a footnote of the amended MAR, or I pointed it out at the beginning of the evidentiary hearing.
Okay.
Because I remember there being confusion about it, and I remember looking up the death certificate.
Okay. The timer, if you just look at the timer and
Oh. Unless you all have any further questions, would ask that you overturn the MAR court and grant Mr. Steen a new trial. Thank you.
thank you. We'll now hear from the state.
May it please the court, I am Sherry Lawrence, a Special Deputy Attorney General with the North Carolina Department of Justice, and I represent the state in this case. The trial court properly denied the defendant's motion for appropriate relief and determined that the defendant's trial counsel was not ineffective. In order to establish an ineffective assistance of counsel claim, I'm sure the court is aware there's two prongs. As I'll begin with the prejudice prong. In light of all the trial evidence here, there's not a reasonable probability that absent trial counsel's alleged errors, the jury would have reached a different result. The defendant defendant's counsel has failed to address two key points here, two key pieces of evidence. The first, this is not simply a case where the victim reported and there was no additional evidence. Defendant makes some omissions here. First and foremost, defendant admitted to taking showers with MS while he was in his custody for at least a little over 3.5 years, when MS would have been 7 or 8 years old. So defendant admitted that. In addition, the defendant admitted to failing to report that MS was allegedly sexually abused by his brother, Richard, which I think these things are two important factors to this prejudice analysis. And the defendant, in anticipation of the DSS looking at the defendant to explain MS's sexual behavior in 2010 or 2009, when he was found in the stall or alleged to be in the stall with another male at school and touching that male in an inappropriate way. In 2009, actually, he was in MS's care during that time. The defendant immediately provided a response to that. He immediately told DSS, well, I know where this came from. I let him stay with Richard and my mom. They slept in the same bed. MS and Richard touched one another while wearing nothing other than their underwear. I think those two things are very key and very key pieces of evidence, and they're very important to this case. Both of those admissions by the defendant corroborated MS's testimony at trial. They corroborated his testimony about the location of the sexual offenses, as well as his statement that the defendant told MS's statement that the defendant told him to tell people that Richard was the one who inappropriately touched him if anyone asked. These admissions provided reasonable inferences of the defendant's guilt of these offenses. MS was in his custody during this time in 2009 when he was found to exhibit the sexual behavior with other males. He was removed at that point. an immediate response was provided by the defendant. There's no evidence here that MS had any motive to lie or any motive to create these allegations against the defendant. Counsel does speculate as to he wanted to be reunited with his family. However, the record does not support that. There's no indication that he had any reason to lie about that. The trial clearly covered his grim and his dysfunctional home life with his biological mom. There was plenty of evidence about his credibility, or I could say lack thereof credibility, his ability to lie. And in fact, Mrs. Lefford, who was his foster placement after the defendant, she stated, well, he likes to lie to get attention. And he was even lying after the fact that he left the defendant. So he was currently lying even in that placement. He had suffered from ADHD, oppositional defiant disorder, PTSD, reactive attachment disorder, expressive language disorder, social difficulties, problems with the primary support group, as well as impulsive control disorder. In fact, he was placed in level 2 therapeutic foster homes, as to indicate that it wasn't a standard foster home. He required some additional treatment because he experienced behavioral issues. The additional records would not have changed the outcome of the defendant's trial. The records would have shown this alleged sexual abuse by MS's sister, a female. However, it involved different sexual acts than the sexual acts with the defendant, an adult male. MS testified the defendant engaged in anal intercourse and fellatio with him. The records would not have explained MS's sexual knowledge and feeling of being anally stimulated by a male and performing fellatio on a male because MS's sister was a female. In addition, the record evidence also shows MS expressed uncertainty about his sexual orientation after leaving the defendant. Defendant's counsel argues that it's irrelevant that it's male, female, or male on male. I think is clearly relevant here because he's expressing that concern about, am I gay? In fact, he asked Mrs. Ledford, was he gay? And he had those concerns of being gay right after leaving the defendant's custody.
Ms. Lawrence, if I can just ask you another record issue. Was there evidence in the record presented at the MAR hearing that the defendant, shortly after MS first came to the defendant's home, that the defendant reported to DSS some sexual statements and acting out by MS?
In the evidentiary hearing transcript, I do think that Ms. Wingard as well as Ms. Hart testified as to their review of the records and what they reviewed, and I think that was included in that. In terms of the trial transcript, there was mentioning of that as well.
So in other words, at the defendant's trial, did the jury hear that shortly after MS first came to the defendant's home, the defendant reported to DSS that MS was proposing to engage in some sexual behaviors and was simulating some sexual behaviors? So did the jury at the trial hear all that?
Well, in terms of the state's case, no, but I do believe the defendant testified as to that. Just have 1 second.
Okay.
Yes, I think the defendant testified as to that in his testimony at the trial. I can't find that reference right now. I do apologize.
That's okay. But at the trial, and I'm asking this because I've commend counsel on your really knowledge of this record and this timeline. At the trial, if the defendant said, I told DSS shortly after MS came to my home, there's something going on with this child. He's proposing sexual behavior and he's simulating sexual behavior. And the jury didn't hear any information, any evidence about this prior abuse. Wouldn't evidence about the prior abuse seem to corroborate what the defendant was saying this child was doing within the first week he came to his home?
And I think the short answer to that is I would say that it would not. And I guess my reason being for that is because we also have to look at defendant's admissions himself, the admissions that he made as to what he did with this child. And I think it's also important to remember the prongs of Strickland and the prejudice prong and considering all of the evidence here. Is there a reasonable probability, even assuming arguendo, that the records that he should have done additional investigation, even assuming arguendo of that, there's still no prejudice in light of the evidence before the jury at that point, even absent these records, because there's more than there's not a reasonable probability that the jury would have reached a different verdict in light of all of this evidence that is before the court, before the jury, as outlined earlier. I think that would be my answer, that it would not. And I think there's also a question as to whether or not it would be admissible under Rule 412, because this court has said in State versus Bass is prior sexual abuse. Defendant would have to establish that. And a lot of this evidence in these records is speculative.
Well, the defendant argues that the state opened the door. And I know you've argued in your brief that the state did not open the door.
Yes.
So that would be an issue that we'd have to deal with.
Yes, Your Honor. But I think even before that, it's pure speculation, because even the defendant in his own brief states, most likely these things would have occurred then. Most likely it would have occurred then. So there's a problem as to time reference as well, which also goes to the deficient performance prong of Strickland as to whether or not that counsel made that strategic decision and why he made that strategic decision. And he does state that based upon the records that he had, it was more than sufficient to proceed with trial. And he made a strategic decision to proceed with what he had. So it's important for this court to remember the strong presumption of counsel to have exercised reasonable and professional judgment in making his strategic decisions to proceed with the trial without these additional cumulative and speculative records. Because this is not a case where it's clear cut. In fact, counsel herself stated, well, most likely it would have occurred during this time, and most likely it would have occurred during this time. And it's clearly speculative and possibly could not have even been admissible here. Clearly, this trial counsel didn't deem it sufficient to do any additional investigation and request these additional records because that was not his trial strategy. And that was clear from what he stated. So I think that would be important as to go into the deficient performance prong, and it would show that he did not, he proceeded with trial strategy. He was not deficient in not doing so. I guess to kind of go back to the prejudice prong, we heard testimony from Mr. Quick. He was the therapist for MS for some time as well, and he talked about his behaviors, and he talked about him engaging in encounters with older males, which goes back to, again, we have one instance that the defendant is saying most likely occurred during this time, and actually even says when he was in his toddler bed. as to indicate is, is pure speculative that he took that and he went and he created this story years later when he's older, 7 or 8 years old, to say he sexually abused me. He performed anal sex when he had not been a receiver of anal sex. Based upon the defendant's theory, he would have been the one that would have been performing it to his sister. And him actually engaging in fellatio with the defendant actually putting his mouth on the defendant's penis, that's something that would have been a clear impossibility to engage in with his sister. So he was the doer for the fellatio and actually the receiver for the anal penetration. So again, it's speculative evidence that does not equate to ineffective assistance of counsel, and counsel clearly made a strategic decision that that would not have changed the outcome, and that wasn't necessary to proceed forward with any additional requests. In fact, he says in his affidavit there were numerous DSS records and reports concerning his behaviors. The evidence was cumulative, it was speculative in terms of these records, and it would not have changed the outcome of the trial. And to briefly talk about deficient performance, this court should review the trial counsel's look at trial counsel's decision in the light of the information available to him at the time and not with the benefit of hindsight. So I think we have to consider at that time what was going on, everything before him. And in light of those circumstances, he stated he made it a trial strategy, a strategic decision to move forward with what he had. There was a surplus of evidence about MS's credibility. These alleged records would not have changed anything, because based upon the evidence at trial, everyone said that MS was a liar. Everyone said that he lied. In fact, MS himself admitted to being a liar and said he was trying to change. So this evidence would not have changed the jury's verdict. Under the facts and the circumstances of this case, there's not a reasonable probability that absent Attorney Wilson's alleged errors, the jury would have reached a different verdict. If there are no further questions, the state will rest on its brief.
Any further questions, Judge Jackson? Judge Zachary?
No.
Thank you very much, Ms. Lawrence. We'll now hear again from you, Ms. McNeil. Rebuttal. You're on mute.
Excuse me?
Oh, I couldn't hear you. You
Oh, okay. Oh, thank you. Yes, first, whether to investigate a case is not a strategic decision. A trial attorney has to do a reasonable investigation in order to make an informed strategic decision about what defense to bring at trial, what defense to make. So it's not, the trial counsel and the state cannot fall back on this is a strategic decision by trial counsel not to investigate. It would not have harmed Mr. Steen's case to request this in-camera review. And in fact, it would have greatly, as we see, aided his defense. Also, the showers, Mr. Steen and Mrs. Steen testified that they did, that Mr. Steen would take a shower with MS. Mrs. Steen was always in the bathroom. MS, as the Ledfords testified, was not great about his personal hygiene. And if he was left alone in the bath, he would play, he would not bathe himself. And baths took a long time. So the Steens both testified that when they had to go somewhere or were in a hurry, that Mr. Steen would hop in the shower with Michael. Mrs. Steen would be in the bathroom waiting with a towel. After Michael was clean, after MS was clean, Mr. Steen would hand off MS to Mrs. Steen, who would, go get him dressed, and Mr. Steen would complete his shower. And Mr. Steen was not aware of the abuse going on in the home, and so that went on in the biological home. So when MS had this behavior, this inappropriate sexual behavior, and Mr. Steen was trying to explain it, his mind jumped to his brother. But neither of those are proof that Mr. Steen sexually abused MS.
Would you agree, though, that him reporting his brother at that late date, after he said he had knowledge of it happening, would cause a reasonable juror to question his credibility?
I think it is concerning that he did not report it. But I don't think it is indicative that Mr. Steen sexually abused MS. I think Mr. Steen, knowing that he did not abuse MS, was trying to find an explanation for MS's behavior, and that's what he landed on. Again, it was unreasonable, given the information in the DSS records, given the sister's sexual behavior, the inappropriate sexual behavior that's in the DSS records, the fact that the sisters never lived with the Steen, it was unreasonable not to request an in-camera review for the counselor's notes and for the DSS records. And if trial counsel had done that, Mr. Steen had a viable defense to these charges. And we ask that you find that counsel was ineffective and reverse the MAR court. Thank you.
Thank you very much. Judge,
Can I just ask one question to clarify something? Defense counsel had the DSS records with regard to MS. Am I correct?
He had the DSS records for the time that MS was with him the second time. The time that covered, MS claimed that, alleged that it was during his second stay. So he did not, trial counsel did not have anything kind of didn't have anything after the allegations were made, and did not have anything before the allegations were made.
prior to that second time of MS being placed in defendant's home.
Correct.
So we're not just talking about DSS records for his sisters and for his mother, right? We're also talking about some of the DSS records for the child.
Yes, for MS, and the counselor's notes, they were not part of the. He had no information from Teresa Grigg, and he had no information about what was going on with MS at the time of the trial. And we requested all of that, and then based on the information we got, made follow-up requests for records.
Okay, thank you.
Thank you. Judge Jackson? Okay, very well. Thank you very much, counsel, for your excellent arguments. The case is submitted, and this session of oral arguments will be adjourned so that we can go into another WebEx room for the second oral argument today.